Hi everyone and welcome to Studio Legal. Here we are with Mr. Hendrik Miranda. Mr. Miranda is a journalist by profession, having a vast experience in the field of law. Lately, he has been actively participating in spreading legal awareness amongst law students, advocates, and public in general. He has also published his own book titled as Justice Need Not Be Judicial. Welcome, sir, to Studio Legal. I want to ask you the first question. Why have you titled your book as Justice Need Not Be Judicial?
The title to the book is Justice Need Not Be Judicial because, it's a bit of an odd title.
Yes.
But because there is a general understanding that everything can be solved only through the judiciary.
Judiciary
It is a misconception, sort of.
Yes.
People think that the moment you have a problem, you have to run to the judiciary. But there are avenues such as arbitration, mediation, and there is one more avenue, that the legislature, which nobody has thought of using it. Even though it existed all throughout, I have not innovated something. I have not discovered something.
Okay.
It was existent and dormant.
Yes.
I just try to utilize it commercially.
So we want to understand the difference between legislature and judiciary. Just a small brief that who comes under the judiciary and who comes under legislative.
Legislature is all the MLAs, MPs,
Okay.
etc. And judiciary is the judges
Okay.
and otherwise other presiding officers of tribunals or any institution that has a judicial, quasi-judicial authority.
Okay. So you mean to say that rather than going towards the judiciary to take a recourse of your legal remedy, or if any person is having any problem, let's say to recover some money or he's in some legal trouble, so instead of going to the judiciary to solve his problem, you are saying that you should opt for legislative practices also, as in you should enter the legislature and ask for a remedy. Is that so? And if yes, then how exactly an Indian citizen can ask for remedy before any legislative authority?
Now, to give a brief example, always you cannot get everything resolved through the legislature. But by and large, there are some things that can be resolved. For example, if I go to a police station to lodge a complaint, by and large, police officers are either ignorant of law or they are under pressure from some authority or something. Some reason may be there why they do not register FIR.
So the next question is, if any person is facing any kind of problem, any kind of legal problem, the first person he approaches is the police officer. So he goes to the police station, he explains his problem, and the police just refuses to take the FIR or any kind of complaint. So in such cases, what a person should do?
In such an event, suppose the ingredients of the offence is such
Yes.
that it needs to be taken as a FIR because it is cognizable, non-bailable and warrant triable.
Correct.
Take the case of 420. 420 comes as a cognizable, is warrant triable and is also non-bailable.
Yes.
So, in such an event, it is duty bound for the police officer to reduce to writing under section 154 of the CRPC 1973.
Yes. Can he opt for the legislative solutions which you have mentioned in your book?
Yes, of course he can. If he approaches an MLA, because this is usually a state affair. Matter pertaining to police comes in the home portfolio, it comes within the state.
Okay.
So if he approaches an MLA, the MLA can raise MLA or MLC. There are various type of instruments that can be used to take stock of a situation.
Okay.
For example, start question, unstart question, then a half-hour discussion, you have calling attention motion. You have so many procedures by which an MLA can ask for an explanation. By writing on his letterhead, all he uses is his letterhead and his pen. And he frames the question in a manner that the procedure is prescribed as to how the questions are to be framed. For example, if something has happened at a particular police station, Azad Maidan police station, then the MLA is required to ask, did this incident occur on so and so day at so and so time?
Yes.
What is the status of this complaint.
Hmm.
Why has the complaint not been registered?
Hmm.
So he'll have to give an explanation. If it is not registered, why it is not registered? If it is to be registered, what does the authorities contemplate to do?
Okay.
So you have got him on always. If he wants to register, he has to explain. If he doesn't want to register, also he has to explain.
Okay.
And the explanation should be tenable in law, not just anything at all.
Okay, so you mean to say that this letter is addressed directly to the police officer, or it
No,
is addressed
to
somewhere
the
else?
state secretary. There are two. One letter will be in a format requesting that this matter be placed in the forthcoming session, on the agenda for the forthcoming session.
Okay.
And the other letter will be the questions that are asked.
Okay, so this forthcoming session will be placed where?
There are 3 sessions in a legislature
Okay.
in a year:
Yes.
monsoon session, budget session, and winter
session.
session.
Yes.
So in these 3 sessions, it should come up, which is the immediate forthcoming session. Suppose that thing occurs now. Now it is the next session will be a winter session.
Okay.
Of course, there are sessions in between also. Special sessions can be called, but by and large, there are 3 sessions in a year. So any one of the session, if something happens in May, it will come in the monsoon session, because the monsoon session starts in June.
Okay. So these problems, these questions will be put up in the sessions, and based on that, the letter will be addressed to the police officer, the concerned police officer, and asking him or to show cause.
The MLA writes that letter and with a covering letter to the secretary of the Vidhan Sabha.
Okay.
They will send it to the speaker. Speaker will approve it after
Yes.
a cursory look. Then it gets printed with the government central. They have got their own machinery,
Yes.
circulated, free of cost. Of course, we don't have to pay anything for that. And then,
Tip 1.
and you don't have to pay money for circulation. Now you have to pay money for this procedure.
Yes, because it is their duty to do it.
So every MLA gets a copy of it.
Okay.
Whether they read or don't read, that's a different question.
Yeah.
But it comes to the office of the police commissioner, who sends it down the line to additional DCP, ACP, and finally to the offending officer,
Yes.
who's the culprit of doing the mischief or
Correct.
whatever wrong he has done. Purportedly wrong, as alleged wrong, you can call it.
Yes.
As of this stage, it is alleged wrong. So it comes to him. Now he is required to give you give an answer, a good explanation as to why he did not do a particular work.
Okay.
Now he cannot give you an evasive answer, because thereby he'll create more problems for himself if your MLA is equally smart. If the MLA knows the ropes of the procedure in the house,
Yeah.
giving an evasive answer will only provoke him to take it for half an hour discussion on the floor.
Okay. So that's.
Because if a proper reply doesn't come, then the MLA has a right under section 94, sorry, not under section, under rule 94 of the house,
Okay.
to ask for half-hour discussion on the subject. So they have to give proper replies. If they don't give proper replies, so in the process, the police officer, when he has to give a
Proper reply. Yes.
what he has taken under 155 as NC, immediately he'll convert to 154 to save his skin.
Yes, of course.
Thereby your job is done.
Yes.
You wanted a FIR, you got the FIR.
This is a different way which I think normally people don't have the knowledge of, and in this way a lot of problems can be solved in a very faster way with minimum fees.
At the most it may take 2 sessions if there is some delay or something like that.
So my next question to you, sir, is that what kind of disputes can be taken up to the MLA and how much time does it take?
On the question of time, I should say 2 sessions would suffice.
Okay.
2 sessions would run into 2 years. Taking into consideration a reply comes, or it may come late, or it may come in the next session. And then if the reply is not proper, it will go for a 3rd section that consumes the full year. Okay, but nevertheless it is far better than the procedure in the court which runs into 10 or 12 years.
Yes, that's better.
Comparatively.
Comparatively.
That is one point. The second question, what was your second question?
My question was that
Where can
what
you
kind
use it?
of where
Yeah.
can you use
Yeah, yeah.
it? What kind of disputes can you address to the MLA?
The matters pertaining to cooperative housing societies.
Yes, which is
Well,
most common I think
yeah.
in Bombay city.
Because there are times when nearly everybody is living in a cooperative society. You have some trouble or the other.
Yes.
From paying a monthly maintenance to leakage to parking of a vehicle to transfer of shares, or there are a number of problems. And matters go to before the deputy register mostly. Some matters are referred to the deputy register and some matters go to the cooperative court. Now which matters come before the deputy register? Under section 32 of the Maharashtra Cooperative Societies Act, you are entitled to take inspection of documents. So if I am one of the flat holders and there is a dispute between the society and myself, and I ask for inspection and it's not granted, declined, which invariably it is always declined by the
concerned authority. Yes.
deputy register who is officiating as a sort of quasi-judge.
Okay.
So he has the power of a quasi-judicial officer, and he says, I will not grant.
Okay.
So the question, the paramount is, under what procedure of law you decline? That is my contention. Under section 32 of the Maharashtra Cooperative Societies Act 1960, read with 117 of the bylaws, every member is entitled to inspect.
Okay.
So how come you decline? So these matters you can pick up in the assembly.
Yes.
That this government servant is functioning in breach of law. So then you can use it for labor. Suppose there somebody has been injured in a factory and he wants some adequate compensation or something has happened and the matter goes before the labor commissioner. By and large, labor commissioners are either in favor of the owners of the factory or management or whatever you want to say. So they'll try to dismiss you off, that you are not entitled to this compensation, or you are not entitled to this leave, or you are not entitled to some medical benefits or whatever. So then again you can complain about this malfunctioning of the labor commissioner.
To the MLAs.
Yeah.
Yes.
You can also use this in revenue matters, taxation, land taxes, or acquisition of land, or you can call it mining. Or you can use it in the municipal corporation as well, but then you don't go to the MLA, you come to the municipal corporator. Because in Bombay city, matters pertaining to municipality are governed by the corporation. There the corporator is a legislator. So under section 66A of the BMC Act 1888, a corporator can raise a matter in the municipal corporation. Similarly, just like an MLA can raise a matter in the assembly.
Okay.
And a member of parliament can raise it at the Sansad.
So in this way, you mean to say that if the government officials are not working properly or as per law, and if the citizens are aggrieved because of that, they have another recourse which is a little stronger also, and that is going up to the MLAs, and their problems will be solved in such case. So this is what is given into this book, the entire procedure as to how to approach the MLA, what the MLA is supposed to do as per the legislative rules, as per the rules which have been laid down in the acts of the house. And the entire procedure is very well written in the book. Link for the book, if you want to buy the book, it is given in the description box below. You can definitely have a look at the book, which is very, very convenient for all the Indian citizens. It's a very thoughtful book which has been created, which has been authored by Mr. Miranda, sir. And it's really nice that people should be legally aware about the legal procedures which are available to them apart from going towards the judiciary. Since we are placing a lot of emphasis on a remedy available under legislature, definitely the MLAs in such cases are given certain powers, certain duties. So where are these powers, these duties written exactly? Under which law, under which act?
No, it is not mandatory that they use it, but they have the power to use it. And it would be prudent for any MLA to use in his own interest. There is no act as such, because in the courts, if we agitate something, it is always under some act and under some section and things like that.
Correct.
But in this legislature, you have legislative rules. So rules 71 and 72 are pertaining to starred and unstarred questions. Rules 84 and 94 are pertaining to discussion on the floor of the assembly.
Correct.
Rule 105 also is pertaining to but it's of public importance, urgent public importance.
Okay.
So there are various rules by which matter can be raised up.
By the MLAs?
By the MLAs.
In the house?
Yeah. The same thing is at the parliament. Under Rule 39, they can call for information which otherwise it cannot be procured. Then you have Rule 197. Matters that don't fit under various other rules at Parliament House will come under 377.
Okay.
Various other motions that are there, if you can take it under 39, if you can take it under 197, you can take it under various other. And when it fits nowhere, not in a short question, not in a short notice question, not in a calling attention motion, nothing, then we bring it under 377. That accommodates everything else.
So this means that they are given vast powers, and it is all either the duties are placed upon them, or there are certain rules which have been drafted under the legislature, and that they are also duty bound towards the citizens.
They are morally duty bound.
They are morally duty bound. Okay,
not
not legally duty bound, but yes, they can help the citizens.
If they want to be voted once again, they want to come to power again, they will look after their electorate.
Okay.
Otherwise, you can teach them a lesson in the next election.
By not voting them.
Yeah.
Anything else you would want to add?
The procedure is not identical to that of a judiciary. It is, but there is some similarity. If people do not listen, if officials deliberately fail to listen, or somebody does not comply with the order passed by the House, there is provision of breach of privilege, there is contempt also. Just like you have contempt of court, you have contempt of the House as well. Contempt of court is not so dangerous as contempt of the House. The reason being, in the Contempt of Court Act 1971, the maximum prescribed punishment is 6 months. But in contempt of the House, it is at the discretion of the Speaker. So it could exceed any amount.
Correct.
Moreover, there is another procedure if people are playing mischief and trying to save the accused. Within the assembly itself, you can move a no confidence motion against the government.
Okay.
Government may collapse. It will result in thousands of crores of rupees losses
So
and a new election altogether.
Thank you so much, sir, for such an insightful session, which is very, very much needed in today's world, because I think that people are facing a lot of problems in following up the court procedures, and this is some alternative remedy which is very beneficial to everyone, and spreading such legal awareness on such platform on Studio Legal. We are very grateful to have you, and thank you for giving such a great session. Thank you so much.